If you, my listener, love the free market and want to defend it, it's good to see what smart folks and intelligent readers of law do with lines of type that are offensive to the free market and offensive to constitutional liberty. In the zoning code of Nashville, or Davidson County, Metropolitan Nashville and Davidson County, there's a line of type that says no clients or patrons may be served on the property. And that is a reference to the property of any of 1,600 people or families that have home-based businesses in the area. Now, there's a problem with that rule, because in many businesses, such as that of hairdressing or hairstyling, you have to have the person come to you. You can't take your chair and your equipment to that party. That party has to come to you. And if you are involved in the music business, as many hundreds of people are in Nashville, and have a studio, well, often you have to have people come to you to mix the music or to make the music. And there is a case filed in the past couple of days in Nashville that serves the interest of people who represent that whole group that face that line of type in the code of Nashville and Hamilton County. They are Pat Raynor, who has a one-chair hair salon in her garage, and then Lige Shaw. Lige Shaw. His name is Elijah, but he goes by Lige. Lige Shaw, a father of a daughter, a single dad, running a studio in his house. And I have on the phone Hannah Cox. She is the director of outreach for Beacon Center, which has filed this 27-page complaint in the circuit court in Davidson County. Hannah, what is the argument being made by Beacon Center on behalf of these two business people?
Hi, David. Well, thanks for having me and for letting us talk about this case. We're really excited to have finally filed it yesterday. It's been a long time in the works. We found Liz Shaw and Pat Raynor about 2 years ago. They both had invested thousands of dollars into converting spaces in their homes. Liz had, as you mentioned, built a home studio in a detached garage that he had on his property, and Pat had spent about $10,000 to renovate her garage into a one-chair hair salon. Both facilities were totally up to codes. Were totally soundproof. We're not bothering anyone. Their clients, as they came, would park in their driveways, so there was no noise or congestion issues whatsoever with their businesses. So they were both very surprised to receive cease and desist letters in the mail in 2015 that basically told them if they continued to operate their businesses that they could have to pay fines for every day that they were in operation, and even look at facing jail time. And so both of them, immediately tried to take action and figure out why this was happening, and were shocked to find out that Nashville actually has a law on the books that says that people cannot operate a business in their homes that has clients coming to it. Now, there's 3 exceptions for that. You can operate a daycare in your home, which clearly has many clients coming to it every day. You can operate a short-term rental property, such as an Airbnb or a home away, where there's often several guests staying in the home for a couple days in a row. And you can have a historical home where you can hold a wedding or another event. So typically, these 3 cave-outs are allowed to have about 12 customers a day, but those are the only exceptions. Otherwise, there is a blanket-wide ban on having someone come into your home and pay you for a product or service.
What about a group home?
Really outrageous.
Let me ask you a question about, is there a 4th exception or exemption for group homes, say, that take homeless people or mentally ill people in Davidson County, Nashville?
I believe that those would be a different zoning. They wouldn't be considered residential, so I'm not sure where they would fall exactly into the code, but it wouldn't be quite the same issue.
Okay, go ahead.
But anyways, as we started looking into this, we realized this would apply to just about anybody. All these kind of things that we all take as a common day occurrence. A kid going to someone's house to get a piano lesson, maybe someone giving a tutoring lesson out of their home, someone giving swimming lessons out of their home, or a yoga instructor. On and on and on. All of these things are equally unlawful under Nashville's code. And so, as we started looking into this, we clearly found that it was very unconstitutional. Residential zoning laws are relatively common. But they're also relatively modern. They haven't been around for very long. I think it was in the late 1920s that the Supreme Court first even upheld that they could be allowed, but for industrial uses. And that's never been very clearly defined. But whatever an industrial use is, it's pretty clear it doesn't apply to Liz operating a quiet home studio in his garage, or Pat having by appointment only one-chair salon in her garage. However, local governments have really taken this and run with it and have expanded zoning laws so drastically that they are really infringing on people's property rights at this point. So we thought it was important to file this lawsuit. We took a longer course than normal and sought at first to have their properties rezoned into commercial properties, just to see if that might be a better route for an immediate solution for them, since neither of them are really able to work as we've been trying to pursue this. And they had overwhelming support for their neighbors at these appeals. I think Liz had over 40 people show up, and Pat had over 35 show up to speak in her support, but it didn't matter. Their appeals were denied. And so this is kind of the next course of action for them.
About Lidge Shaw, Elijah Shaw I don't know how well known he is in the music world, but he has some big names under his belt as a music engineer. Who are some of the people that my listener whose names my listener might be familiar with as clients?
Absolutely. Lidge is a really cool guy. He moved to Nashville, into the East Nashville neighborhood in the early 1990s, which for your listeners who aren't familiar, nobody was moving into East Nashville in the early 1990s. It was a rough neighborhood. It was very patchy. There was a lot of crime, and artists like Lidge started moving in and really changed things around, where now East Nashville is a thriving artistic community. But it was people like Lidge who took the chance and moved there before that, was the case. And so he's been in place for quite some time, built this home studio, and has produced Grammy Award-winning performers. I think he's worked with John Oates, Jack White, Wilco, Zac Brown Band, Adele, and he wanted to, when he had his daughter, have a bit more flexibility in his schedule and be able to spend more time with her, which is why he built this home studio in the first place. But home studios are very common in Nashville. I mean, really, you would be shocked to find out how many people have a home studio. So when you think about what this means for Music City and for the music industry as a whole, a lot of the big studios are going away. They're too expensive. People can't afford them, and they're not even necessary. You don't need these big grand studios anymore. So going to someone's home and recording is very common practice, and he's had some really big clients that have come there. And when he received the cease and desist letter, which, by the way, neither Liz or Pat have ever been privy to who actually turned them in. They have no way of knowing who or what or why they were turned in for. But basically, they've had overwhelming support from their other neighbors who they've gone and spoken to. So it's kind of up in the air about what actually happened that caused him to get this letter. But when he did get it, he reached out to the codes department and immediately trying to figure out, what could he do? How could he be in compliance? Trying to defend his livelihood, and was told at one point that they were going to remove all of his equipment, which is worth tens and tens of thousands of dollars. And he eventually managed to kind of talk them down, and they basically said he had to take his address off of his website. He could not advertise his services anymore, and that he couldn't even record a podcast, or they would come in and shut him down and take all of his equipment. So really, even though he still has the studio, he's not been able to operate at full capacity. He's really lost a lot of clients due to this, and it's really, put a stint in his livelihood right now. Pat was a widow. Her husband passed away, I think, in 2009, and left her with an extensive amount of medical bills and also the loss of his income. But she was, determined to try to keep the house that they had built, and basically determined to convert her garage into a styling salon, because it saved her a lot of money. I think it's about $135 a week to rent a space in a salon. So that saved her money, allowed her to be able to, keep existing on her single income and pay her bills and stay in her home, basically. It also kept her at 65 years old from having to get out and about every day and drive, which can be dangerous. And I think that highlights another point with the home business ban that's so ridiculous in Nashville. I think it's well documented that we're having a lot of travel issues here. We have a lot of congestion. We've had a really ridiculous proposal put forth by the mayor's office, where they're wanting to spend several $1 billion over the course of 25 years to implement mass transit. Well, this is the kind of solution that we should be looking at. How do we keep more people off the roads? Because we already know in other cities that people don't use mass transit systems. They don't actually reduce congestion, especially in cities like Nashville that don't even have much of a central location. They're very spread out and dispersed around suburbs. So one thing we should be looking at is how to get more people off the roads and traveling during the 9 to 5 traffic. Home businesses do that. So, this was a good thing for Pat. It was a good thing for the community, and yet she's also had her livelihood shut down and is now having to pay extra money to go work in somebody else's salon.
Well, is there a public benefit, public safety argument that you expect to be raised by the codes enforcement people? What is their best argument to shut down these two people and all those they represent?
I don't even think it is a public health or safety argument that they're going to raise. We have several Metro Council members on record, as well as several responses from the Codes Department, where they really are very flippant about this law. They basically recognize that it's a ridiculous law, but they seem to think that their don't ask, don't tell policy of enforcing it is working just fine. We even have 2 councilmen this year saying that this is a silly law, but it works just fine. There's no problem because they don't really enforce it that much. Well, that's fine for most of the 1,600 home businesses that we estimate are operating in Nashville, but for the few unlucky people who randomly get reported by a nosy neighbor or someone who's disgruntled with them or who knows why,
a business rival.
That's like pulling the rug out from someone for no reason, and it's just as random enforcement. It's like a lightning strike. You don't expect it to hit you, but it could, and when it does, you really don't have any line of defense. So their excuse for keeping this law on the book is really kind of crazy. It doesn't seem that they have a strong defense of it, other than it's always been in place. It doesn't seem to be broken. Why fix it? But it is broken because it's taking away people's right to earn a living. And so you're saying that this is an unjust ordinance because it's unequally enforced. Absolutely, it's unequal application of the law. It's definitely unconstitutional, and it doesn't matter if you take away one person's right to earn a living or if you take away 1,600 persons. It still matters, and I think that our councilmen and our codes department should be a lot more concerned about that. I don't think that you can look and say, well, this hardly ever gets enforced, so it's not a big deal. Well, it's a really big deal to those people who are out thousands and thousands of dollars and out of their livelihood.
We're talking with Hannah Cox from the Beacon Center. She's the director of outreach. This is a nonprofit organization that is pursuing the free market, pursuing an end to occupational licensing, and here attacking Nashville and Davidson County's one-sentence rule that forbids customers from coming to your business if that business is in your house. Well, Hannah, what is the main argument in the Constitution that favors my listener in regards to this kind of regulation? What is the main argument, protection for liberty in the Constitution? And what do you plan to say about those provisions in this case?
Right. Well, I would definitely encourage everybody, if they're interested in finding out, all the specifics about the case, to head to our website, which is beacontn.org. We've got a great case page up, a video, a full blog about both Liz and Pat's stories, as well as some information that kind of digs into the merits of the case. But essentially, what we're going to argue is that since 1926, zoning laws have grown far more intrusive in scope. In 1974, there was a Supreme Court decision in New York that started prohibiting graduate students from being able to sign leases together as housemates. There was another that had to deal with grandparents living with their grandchildren, and basically we've just seen this grow exponentially during that time period. And as a result, municipal governments today believe themselves free to abuse the zoning power to regulate or prohibit almost anything they want, even if doing so has no plausible connection to a legitimate government issue like health or public safety. And that's exactly what's happened in Nashville. Liz and Pat, they're law-abiding citizens who have overwhelming support of their neighbors, no criminal record, and a safe and unintrusive home business. It's far less intrusive than many of the home businesses, the carve-outs that I mentioned earlier. So it's unfair to single them out. We're going to say that Nashville's home business law is dishonest. We're going to use the records, like I mentioned, of even the council members saying that this is unequally enforced. And we're going to also say that residential zoning laws cannot be used to regulate a home-based business that can't be seen or heard from the street. Residential zoning laws are meant to maintain the character of residential neighborhoods, not tell residents how to behave inside their homes. So the Tennessee Constitution, which actually affords greater protection for substantive due process than the federal Constitution even, it prohibits such an intrusive regulation of someone's use of their home. The government, could never prohibit Liz or Pat from having a friend over for a visit. It doesn't make sense that the government could prohibit them from having customers over as well.
So there's no compelling state interest, Hannah Cox, in this ordinance. There's nothing that's compelling that for public safety, for the right exercise of police powers, and the like, we have to have this ordinance on the books.
Exactly. But, what is going to be meaningful is this victory in court. When we get it, I think will expand legal protections for people's property rights. It will establish legal precedent that recognizes meaningful limits on the zoning power of municipal governments. And I think it will vindicate the right of all Tennesseans to earn an honest living in their homes. And that's two things that we at the Beacon Center are highly concerned with. We are adamant defenders of people's property rights. And we're also adamant defenders of their right to earn a living. We've done a lot in this sphere. That has to do with occupational licensing. We've passed the Right to Earn a Living Act in the state that requires the General Assembly to review all of our regulatory boards and kind of the onerous burdens that they're putting on workers. And this kind of goes hand in hand, because I think that what you have right now is an intrusion of someone's right to earn a living, and also an intrusion of someone's property rights. That's why this case was definitely of high interest to us.
Well, among the states, among the 50 states that have bad offenses against the right to work, how bad is Tennessee, Hannah Cox?
Tennessee's pretty bad. I think we're ranked 11th worst by the Institute for Justice for our occupational licensing burden that we place on people. From the Beacon Center's research, we think we basically blocked about 15,000 people in the past year from accessing a good job due to our occupational licenses. We had 112 occupational licenses on the book. Beacon has actually sued over 2 of those, and through our work, 2 of those have been overturned now, but we still have 110 more to go. And these are licenses that basically predominantly block low and middle income people from accessing a job. And this is something that, we've got this lawsuit that we filed that we think ties in very closely with that work, but we're also going to continue to be working on this issue from a legislative perspective and introducing our Dirty Dozen in the next session of the General Assembly, which are the occupational licenses currently still on the books that we think are the most ridiculous. And we're going to be advocating either for complete repeal of some of those licenses, or for some of them we'll be advocating for the hour requirements to be reduced, the fees to be reduced, perhaps incorporating more of an apprenticeship approach to some of these things. But the point being, of these various different occupational licensings that we're going to be reviewing, very, very few of these licenses on the book have an actual legitimate public health or safety component to them. Predominantly, when you look at what currently requires a license in the state, these are occupations that simply the people on the board have an invested interest of limiting the amount of people in the field because they want to keep their costs high and their prices high and their revenue high. And so it works for them to make it harder for people to enter that field. And it also works for them to have requirements that make these people go and pay for long hours in a class to do a job when it's really kind of unnecessary. If you look at even our cosmetology degree, we require 1,500 hours to become a cosmetologist in our state. That is more hours than it takes to become a cop, than it takes to become an EMT. That's ridiculous. There's no reason someone needs to be in school for 1,500 hours to become a cosmetologist. Some of these things could be lowered. You could include apprenticeships so that people can actually learn on the job, start making money earlier, and basically just make it easier for people to enter that field. So people should definitely be on the lookout as we start unrolling those. I believe we've been releasing blogs on our website kind of highlighting what those will be. I know that a few of them, for example, are makeup artists. You have to have a license to be a makeup artist right now. You have to have a license to be an auctioneer. In Tennessee, I think we're one of the few states that requires that. You have to have a license to be a locksmith, to be a security alarm installer, a hair braider, all of these things that there's absolutely no reason we should have the government involved at the level that they are in these careers. So that's something that we continue to work on both in the courts and at the legislature, and that we're very passionate about reducing and making sure that we can just help Tennesseans get to work. A lot of people just want to earn a living, and we shouldn't be blocking them from doing that.
We're talking with Hannah Cox from the Beacon Center, and the website again is beacontn.org. That's beacontn.org, and I suggest you, my listener, become a subscriber to the blog there. It's beacontn.org, and you'll see that there is really, in most of these occupational licensing claims, no compelling state interest for there to be this obstruction in the free market or the obstruction of the free market. And as Hannah Cox explains, it is essentially all these bans on occupations that make them illegal unless practiced under license is a kind of cronyism, and it is highly, highly discriminatory. And who suffers the most from this kind of discrimination? So, Hannah, let me ask you, who suffers the most from economic discrimination through cronyistic statutes that gives the state ownership of occupations?
Yeah, it's definitely our low and middle income earners in the state. If I have to go and pay $400 a year to work in my profession, that really sucks, and I'm not going to like doing it, and it's going to be hard. I'm probably have to set aside money to do it, but I can do it. But for a lot of people, that is just simply out of reach. For a lot of people, if you want to be a hair braider and you have to pay thousands of dollars to go to school for 300 hours to learn to do something you already know how to do, and then turn around and pay the government another fee in order to do it, so you're out thousands of dollars before you can even start working. That's something that a lot of people in our state simply cannot do. Whereas if we were to reduce these burdens, they could get to work, they could create other jobs, they could provide themselves a living. I know I've talked with you about this before, but we launched a lawsuit last year that was over the shampoo license that was on the books that was blocking people even from shampooing hair. But as we were talking to some of the women in Memphis who we were working with on this law, we found out that one of them, Deborah Newtall, had pioneered her way in the African hair braiding movement in Memphis in the 1990s, had pulled herself as a single mother out of poverty, had started employing dozens of other women, was training them in her salon how to braid hair. They were then going out and earning livings and being able to pull themselves off of poverty. She bought herself a house, and then all of a sudden the state came in and said, oh, no, you have to have a license for that. And it wiped her out. She ended up having to move states. She just left the state and went to Mississippi because she could not pay the thousands and thousands of dollars it was going to take her to now reach the new requirements the state had put in place. And furthermore, she didn't think she should have to. She was already a very qualified business owner. She knew exactly what she was doing. She was renowned for her talent. Why should she have to go and pay the state money to simply work? It's absolutely ridiculous and out of control.
Hannah Cox, thanks for joining us.
Thank you.
Hannah Cox is from Beacon Center in Nashville. Beacon TN is the beacontn.org is the website. And I want you, my listener, to go today and subscribe to the blog, beacontn.org. Tremendous work being done in your favor here in Tennessee and across the South. David Tulis.
The Tennessee Valley's news, talk,